today we're going to be talking about situations that sometimes comes as a real shock to families. Think long-term mistresses or when someone has multiple de facto partners. First of all, how do you have the time to do that? Anyway, these relationships, they can end up costing far more than people expect, especially if things fall apart. Under family law in Australia, you don't always need to be married to make a claim for a property settlement. In some situations, a person can find themselves facing not one but two or more property claims from different partners. All right, what a messy world we live in the real world. It's crazy to think this happens. We're joined by Attwood Marshall Lawyers Family Law Special Counsel Hayley Condon. Good afternoon to you, Hayley.
Good afternoon to you, Carla, and to your listeners.
Honestly, this does read like it's from a soap opera. But, do you actually see situations where this sort of thing plays out where someone's been in a long-term relationship and then they've also been married or in a relationship with multiple de facto partners? How does that end up becoming a legal issue then when things turn south?
The secret relationship, Carla. It's an interesting concept that a person can be in more than one relationship that is recognised under the Family Law Act, and the impact that this can have financially and otherwise if one or more than one of those relationships breaks down. But it does happen.
That's fascinating to me. We're not talking about polygamy. You're not being married to multiple people. It's having relationships that are significant enough to tip them into de facto status, right?
That's exactly right. That's not what we're talking about.
Okay, so when a court is trying to work out whether someone is actually in a de facto relationship, what are the sort of the things that they look at? Because I thought in order to do that, you had to be living in the same, address at least. But you can't if you've got multiple relationships on the go.
Now that's a common misconception.
Okay.
Yes.
Right.
If people are hanging their hat on the fact that we live in separate residences, well, that doesn't exclude a de facto relationship existing. It's all part of the ingredients that a court will look at when determining whether a de facto relationship exists. So I'm just going to take you a step back there first.
Okay.
So when we look at de facto relationships, just because you're in some form of a committed relationship doesn't mean that it meets that criteria under the Family Law Act. So what a person would need to show is firstly that they're living together as a couple on a genuine domestic basis. Park that. We'll come back to that.
Yeah.
And either that the period of the relationship or the total periods is at least 2 years.
Okay.
Or if they can't show that there's a child of the relationship.
Okay.
Or if they can't show that the relationship is or was registered. So in Queensland, under the Civil Partnership Act, that's exactly right. Or the applicant party has made a substantial financial or non-financial contribution during that relationship, and a failure to make an order would lead to a serious injustice to them. So you have to show that you're living together as a couple on a genuine domestic basis, and one of those are the factors to be eligible to make a claim. Now, what does living together as a couple on a genuine domestic basis mean? Well, this is the really tricky part under the Family Law Act.
Right.
There are factors that a court will take into account when determining whether a de facto relationship exists, but there's no prescribed formula under the Family Law Act. So there is no tick-check box that if you tick all of these boxes, yes, you're in a de facto relationship. It comes down to the court looking at certain factors, and I'll outline those for you in a moment, and looking at the totality of the relationship and weighing up as to whether it reaches that threshold.
I don't understand who would have the time or energy to balance out multiple relationships, let alone make them appear de facto. That will be tough.
Well, there's obviously someone out there, Carla, because otherwise the Family Law Act would not contemplate this.
Yeah, or have provisions for it, or at least even have your speciality in this. I mean, it's just one small aspect of what you do, but it is fascinating to think. Look, the 4BC open line, thanks to Watch Smoke Alarms, is 133 882. If you've got a question that you would like to ask Hayley, maybe you have a secret partner, maybe you've got the second family is the one that always is thoroughly troubling and amusing at the same time. I don't know how people can juggle all of that and have a secret family in another state or another city or even in the same suburb. It's bizarre, truly weird.
It does happen, Carla. It does happen.
Wow.
So to help your listeners to get a bit of an idea as to what factors the court looks at when deciding whether a de facto relationship exists, there is a list of those in the Family Law Act. And those are, they look at the length of the relationship. They look at whether a sexual relationship exists. They look at the degree of dependence or interdependence between the parties. They look at the ownership, use and acquisition of property. They look at the degree of a mutual commitment to a shared life. They look at the care and support of children. They will look at if that relationship is or was registered, which we spoke about before. And they will look at the public aspects of the relationship. Are you presenting to the world as a couple?
You're a couple. But what happens if, like I was saying about secret families, what happens if one of the partners had no idea that their partner had multiple other relationships going at the same time?
Well, that's interesting, isn't it?
Yeah, it is.
It makes no difference.
You need to give me case studies, Hayley. You need to tell me who, when and where and why, because don't worry about it. There's
few privacy issues.
No, don't worry about it. Just share, spill.
Just moving past that. It doesn't matter under the Family Law Act.
Really?
If those partners don't know about each other, as long as the relationship meets the required criteria under the Family Law Act to be eligible to make a claim, then a claim can possibly be made. Not by one, but by two of the spouses.
Or more.
Well, it depends how many relationships.
Oh, I mean, I am like Shane, who's just texted in on 0499 880 882. I'm exhausted thinking about it. Shane says, I'm exhausted looking after one wife's list of things to do. Where do people get the time for this rubbish?
Well, it is true. And it can be very costly for that person that is in more than one relationship, not just financially. So if a property settlement order is made, for example, and they have to pay money or transfer property, but also secondly, personally, think about dealing with the fallout with that other spouse because they're going to find out at some point.
Yeah, well, yes. It is amazing. Mark from Gbung has asked the question, what about inheritance? So maybe there's like kids involved or, if someone passes away and then another family tries to take claim, I guess.
Well, that is another relevant factor as well because this does flow into our succession laws, which are obviously state-based, whereas family law is Commonwealth-based.
Yeah.
But if we look at Queensland, for example, well, again, you can be married to somebody and be in a de facto relationship. The definition is slightly different because for succession law, normally a person
greedy comes to mind.
Well,
or dumb.
Well, they might feel they're owed their dues after all of this.
Oh, I know. I mean, the person that started multiple relationships without realizing.
But yes, there is also potential there for another family, so to speak, to come out of the woodwork and make a claim against the estate if adequate provision has not been made.
Okay, 133 882 is the 4BC open line. Thanks to Watch Smoke Alarms. We've got a call here. Alan from Corona Downs has called through. Hello, Alan.
Hi, Carla.
G'day, Alan. You've got a question for Hayley.
Yes, please, Hayley. So I'm wondering what happens if somebody's been in a long-term de facto relationship and then they separate. Is there a time limit on making a claim?
There is, Alan. It is 2 years from the date the de facto relationship ends. That's the statutory time frame. However, once that expires, a party can still potentially make a claim out of time, but they have to get the leave of the court, and that's not that simple. So really just work on that 2 years.
Okay, good. Thank you.
So 2 years to make a claim there, Alan. Thanks for calling through. I mean, it is one of those things. It's super complicated, I guess. If for anyone who finds themselves in this sort of entanglement, what's the most, I guess, important thing they should do or should understand about their legal and financial risk?
I think the most important thing that they need to keep at the forefront is this. If you are married and you are in a relationship with another person, or if you are in more than one relationship with multiple people, depending on the nature and extent of that other relationship, even if you don't think so, could very well be regarded as a de facto relationship under the Family Law Act. And if that is the case, it exposes you to a property settlement and or spousal maintenance claim if one or more or any of those relationships breaks down.
It is fascinating. I feel like we've just scratched the surface, and I am going to, when the statute of limitations runs out, I want to find out more information about these people who find themselves in this situation. That, to me, is the crux of it. Look, Hayley, you are ever professional, and I appreciate you coming in here for our legal lowdown. Attwood Marshall Lawyers, Family Law Special Counsel, Hayley Condon. Of course, they can catch up with you at Attwood Marshall Lawyers if they need more information. Thank you so much for coming in.
Pleasure, Carla.